Alright, so this is one of our first crowdfunding campaigns, and it's up on the website now under we have cases looking for funding. And this case is Aspen Fitness Products versus Innovation Ventures. And the case is about the energy shot diet supplement market, which is dominated by 5 Hour Energy and Innovation Ventures, who own 94% of $1.4 billion growing market. And the Aspen Fitness and its product OnGo Energy were the second entrants into the market. And the reason you've never heard of OnGo or Aspen is that 5 Hour and Innovation have used their influence with the FBI and the court systems to bring frivolous lawsuits, as well as interfere with distribution arrangements and Aspen and OnGo's business relationships. 5 Hour and Innovation have sued Aspen, and Aspen has countersued for tortious interference with its business. This case went through our underwriting process, and our entire underwriting file is up here on the website. First, there's the underwriting questionnaire, which should give us a basic overview, and that should be up as well. So this is the underwriting questionnaire. It should give you some contact information and some basic information about the status of the case, who the attorneys are, where they are in the process. It looks like they're in discovery prior to dispositive motions, and it gives some basic case information. So here it says a 5 Hour pursued a baseless criminal complaint against OnGo, and OnGo's offices were raided. What happened after that fact is that no criminal prosecution was brought against OnGo, but Innovation or 5 Hour did bring this civil suit. OnGo countersued, and our position is that the countersuit has merit, and the underlying Innovation 5 Hour prosecution is not all that strong. So here it outlines some of the litigation expenses to date. They're about $50,000 in, and they look at their damages inclusive of exemplary or punitive damages at $479 million, and expected duration is 2 years from now. So here we have the underwriting file. It's on the website as well. It explains basically what non-recourse litigation funding is. And it's a contract to assign revenues from litigation. And in this particular offering, the anticipated ROI over 3 years is 250%. If it should go that long, 100% the first year, 75% the 2 subsequent years. So the return on investment is secured by a UCC lien or an attorney lien, up to 10% of the gross revenues of the case. Contracts typically have some provisions regarding compromise of the case. If the case settles for a less than compromise or less than optimal value, then there are some provisions to compromise the lien. Lodestar typically negotiate that kind of a scenario, and it gives some characteristics of the lien, and in particular, the lien survives bankruptcy. So it also gives us some background about Lodestar's role in the process. Lodestar is obviously the broker. They will charge a commission. They will secure the lien, provide ongoing case management and support services to make sure that the litigation goes well. Lodestar is presently working on a live exchange and market platform whereby some liquidity will be offered for the contracts. There will be a updated ask, an immediate cash value of the contracts, for the contracts. Lodestar has done all the underwriting, right? And Lodestar will broker follow-on or other offerings. On this particular case, we do have a follow-on offering of $600,000 in funding from a hedge fund. We don't have a bankable law firm yet to step up and accept the funding. But when that happens, it becomes a very good prospect that this initial round will be bought out, or at least there'll be an offer to buy out all the investors in this initial round. So it looks like the money's there. It looks like it's a strong case. The case is only getting stronger as it proceeds, and there's been some initial interest, and even a soft offer contingent on securing the right counsel. So it gives a little timeline of what the case is, the Innovation Ventures case versus Aspen. The main issue here is that the litigation's imposing significant discovery costs and litigation costs on Ongo. This initial funding will defray some of that, allow the case to develop to a point where a second round or follow-on offering can be made, or the right counsel can be secured to make that happen at this point, since there's an offer already on the table. So here's just some of the claims that Ongo's looking at: antitrust, abuse of process, tortious interference. The tortious interference claim has survived a summary or dismissal motion. And there is an outline of damages here, claiming damages in the neighborhood of $470 million with punitives or soft damages. The damages highlights, however, are there are some solid examples of what's called direct or consequential damages. One being an Exxon distribution deal, which interfered with by 5 hour. McLean's distribution deal, $41 million, interfered with as well. And some miscellaneous and other deals. It looks like $100 million in damages roughly. As part of the seed offering, there will also be a attorney support letter from the current present counsel of record. They're Vander Garza. They're having some success, at least at the preliminary stages. Give some background on the case. What the claims are from the initial complaint, what the counterclaims are. Some of the procedure, the prospective settlement timeline, strength of liability, and damages. And prospects of a settlement. So the letter's up there as well. So in the initial offering, the underlying file has to do with a second round offering. The initial offering, we're offering a $50 contract. It would be recourse principal plus 2%, 200% per annum, capped at 600%. So the first money in gets the biggest return. So we're looking for investors on this initial round. Strong case, strong perspective for follow-on rounds of funding. For a commercial contingency case, this is the kind of case you want to invest in. LodestarCrowdfund.com, 616-439-4004. Call us and open up an account. Thanks.